So the topic that is visible now is law regarding terrorism and a special reference to cyber terrorism. It contains three variables. First is law, second is terrorism, third is cyber terrorism. What is law? A topic on which volumes and volumes have been written, but still there is no clarity, so therefore I am also not taking this risk of defining what law is. I'd only say, as I have said in previous various lectures, law consists of maybe 5 or 6 things, so that the ambit of the research scholar is, ambit of the researchers, ambit of the faculty members is very clear. What are those 5 things? I often call it P5. First is the principles of law. Where is principles? Principles are not written. For example, presumption of innocence is a principle of criminal law. Presumption of constitutionality, that every law is constitutional, is another principle of law. There are a lot of principles. Law is full of principles. Principles are there in contract, in tort, in criminal law, in human rights, and so many principles. So law is something, principles of law is essential part of law, though they are not written, not mentioned. Second is P2. P2 is provisions of law, provisions with the provision which is written in black and white, unlike principles which is not written. Third is precedents of law. When I say precedents of law, that means that judicial decisions, they are also part of law for the purpose of researchers. P4 is policy of law. Policy of law is something which keeps on changing with the change in government. Principle remains intact. They are permanent in nature. So first is principle, but fourth is policy. For example, zero tolerance policy. 2014 onward, we are finding that government is following zero tolerance policy against terrorism. बहुत सख्ती से लागू कर रहे हैं. But prior to 2014, government was not using zero tolerance policy. Maybe in theory but not in practice. They were little soft. It is very difficult to say which policy is correct policy. It is only the time in the future will say. So the policy keeps on changing with the passage of time, but the principles remain intact. Then comes P5. P5 is professional opinion. For the purpose of researcher, that is also a part of law. What is the opinion of Professor Dicey? What is the opinion of Professor Derrett? What is the opinion of Professor Bodenheimer? What is the opinion of Kane? What is the opinion of Subramaniam Bharati? What is the opinion of Vivekananda? What is the opinion of Dr. Ambedkar? What is the opinion of Pandit Jawaharlal Nehru? What is the opinion of Sardar Patel? What is the opinion of Law Commission of India? What is the opinion of Professor Upendra Bakshi? The professional opinion. So for a law researcher, law means law is not just black and white law. Law is a bouquet of 5. P6 can also be added, that is practices. They can also be part of legal discourse. Second point is terrorism. What is terrorism? That we will discuss in the maybe after 2-3 slides also. Terror means किसी को डराना, धमकाना. The literal meaning. Ism means when ism indicates some type of philosophy, some type of a permanent way to do that thing. Ism. So when terror becomes ism, it becomes terrorism. Means when your way of life, when your philosophy of achieving something is terror, you use the means of terror, that becomes terrorism. But more specifically, Terrorism means when you do something, someone does something with certain political objective, with certain ideological objective, with certain religious objective, then it is terrorism. So, if a murder creates terror in me, or a group of people do certain things only by killing people, they rob people, that also creates terror. That is also a way of life for them, whose only purpose is to kill people and get rich overnight. That is not terrorism. Why? Because they don't have a political objective. हमको अलग देश बनाना है. No, they don't have that objective. They don't have some ideological objective. I have to place this particular ideology in this country. कैपिटलिज्म को हटा के कम्युनिज्म लाना है, कम्युनिज्म को हटा के कैपिटलिज्म लाना है. फॉर दिस पर्पस आई एम यूजिंग द मीन्स ऑफ टेरर. दैट बिकम्स टेररिज्म. रिलीजियस, हमको जो है सारे वर्ल्ड में इस्लाम का झंडा फहरा देना है, यही जिहाद है. मिस इंटरप्रिटेशन ऑफ इस्लामिक टेक्स्ट विच इज वेरी मच प्रिविलेज. धर्म के आधार पर खालिस्तान बनाना है. तो ये जो धर्म के आधार पर ऑन द बेसिस ऑफ रिलीजन व्हेन वी डू so on the basis of some political orientation, some ideology, some maybe religion, then we say it is terrorism. So terrorism has two meaning. One is a literal meaning, which is a dictionary meaning, which means when you create terror. So even my child, when I slap him, when I scold him, he can be terrorized. That is not terrorism. Terrorism has a specific meaning. If it has a political purpose, when the means of terror is means of killing is used for the purpose of some politics, for the purpose of some ideology, for the purpose of some religious goal, higher religious goal, then we say it is terrorism. But as the description is very vague, therefore there is no consensus of what is the definition. And this is one such reason, even in the United Nations, people do not agree. For last maybe 20 years, a discussion is going on, what is the definition and description of terrorism. And the one convention is there which is still pending for last maybe 20 years. But we can understand now what terrorism means. India is probably the most vulnerable country. So we understand then better than anybody else. Then cyber terrorism. It is simple. When we use cyber mode, when we use virtual mode, when we use computer, when we use cell phone, when we use scientific tools to create terrorism, that is known as cyber terrorism. Cyber terrorism, while terrorism is not defined, terror activity is defined under Unlawful Activities Prevention Act. Cyber terrorism is defined under Information Technology Act section 66 capital F. But then that meaning is entirely very limited meaning. Now the whole discourse of terrorism all over the world is now focused on two points. Why terrorism? What is your purpose? What do you want? You want justice? Is it a fight for justice? So you kill people who kill children for justice? Is it a fight for human right? Is it a fight for unemployment? Why terrorism? Very difficult. Every terrorist group has its own justification. Some say that God has given us this right to do. We are doing it for God. Therefore, they misinterpret the word jihad. Same is the case of Khalistan. Second is abuse. While these criminals who are terrorists, who kill people for no reason, who have no mercy, who just want to disintegrate many countries, including India, That is one party, the state is other party. And state excesses and state abuse is another focus. A balancing is required, which is a very difficult task. So these are two focus. So we want to do research work. Both areas can be worked on, abuse as well as why terrorism. I have moved the PPT. Now, United Nations has identified 6 areas of concern in 2001, in the beginning of this century. And these 6 areas of concern, terrorism is one of them. They are threat of civilization, international community, international peace and security and humanity. In 2001, Schedule 4 of the United Nations Security Council Resolution 1373 says that every state has to make very strong law. So make it a serious offense in domestic laws. So if we have a law and laws are serious, it is not because we are making it, but because it is an international demand. Here is the area when the confusion begins. Because many people, they think that India is making many laws which is probably not required. Our laws are harsh laws. But that is not the fact. Fact is that the whole world is making laws. It is the United Nations resolution which says that serious criminal offences should be made under domestic laws, and punishment should duly reflect seriousness of such terrorist act. So this is the United Nations resolution which says not only to India but many countries to make laws for terrorist activities, because terrorist activity is mindless. But at the same time, it is our responsibility to see that in the name of terrorism, innocent people are not implicated. And therefore I would quote before you one of the observation of a quote which is further quoted in Inter-American Commission on Human Rights, that the state's national and international obligation to confront individuals or groups who use violent methods to create terror among the populace and to investigate, try and punish those who commit such acts means that it must punish all the guilty. So the first responsibility is that all guilty must be punished. No guilty should be spared. No guilty should get the benefit of doubt. No guilty should get this technicality of laws. But then it should be done only to guilty, not to those who are innocent. Just because we are not able to find some guilty person, it is not that we should implicate some person. And this happened in many places, including India. Many cases of abuse, some of them are correct. One such example is Akshardham attack case. In Akshardham attack case, the Supreme Court finally found that the police have indeed picked up innocent people. Fortunately, they were not punished, but unfortunately they had to lose around more than 10 years of their life. And the most unfortunate part was the court has not given them any compensation. They are still struggling. And another unfortunate part was those victims of terrorism, those accused who were made accused, they became the vehicles of some people, some NGOs who in the name of human rights have used them, have used such type of victims, such type of accused who were wrongly implicated. And these people, these NGOs, some of these human rights activists, they used forged method, committed forgery before the Supreme Court, before the courts, in order to gain mileage. in order to get maybe some type of some popularity. That was another unfortunate aspect. That was where I was suggesting that why the issue is very complex. That there are misguided people who are misguided by religion, wrong interpretation of religion. Then the state is also a party who is misusing the law in many cases, because they think that without misusing it is not possible to tackle terrorism. Then there is a hue and cry of human rights violations. Some of them are true, but not all of them are true. And fourth is that such victims, such accused who are wrongly implicated, they are being used in international and national forum where people are taking mileage because of their sufferings. So we have to be very careful when we do research work. Just to give you a description of what terrorism means and how is it different from crime. Suppose anyone kills 5 people, 5% in maybe some vicinity. Take example of Chandni Chowk. He kills 5 persons. Everyone is a neighbor. So certainly killing of 5% is very serious. Very serious. We would be terrorized. People would be terrorized. Certainly they would be terrorized. But is it terrorism? It is not terrorism. Why? Well, there is an intention. Intention to kill. What is the motive? Motive may be to take revenge. Motive may be to rob these people. Motive may be something else also. But that is not terrorism. Suppose in the Chandni Chowk vicinity, a bomb blast takes place. Only one person is injured, no one killed. What the purpose was to challenge the state. Some Khalistani forces, some Islamic jihadist, some person from maybe Naga terrorist, some Naxalite, they have committed a bomb blast. No one was killed. But the purpose was to challenge the state, to challenge the sovereignty of this country, to challenge the integrity of country. The motive is to disintegrate this country. So mere one bomb blast, which has not killed anything, will amount to terrorism, while killing of 5 people will not amount to terrorism. One is crime, other is terrorism. So terrorism means it needs specific intent. Crime needs general intent. Terrorism generally needs specific intent. And it is one such reason why in Hitendra Vishnu Thakur versus State of Maharashtra 1994, the Supreme Court has held that every terrorism is a crime, but every crime is not terrorism. This the authorities should understand, that I may be a criminal, but I may not be a terrorist. Just because I have spoken against the state does not make me a terrorist. I may be a criminal. गुस्से में आकर के मान लीजिए कि हमने जो है किसी पुलिस वाले को मार दिया. That is not always terrorism. That may be a murder also. That may be something else also. So let us not be carried away. This is third confusion. That let us not be carried away by every such attack and declare that it is a terrorist activity. No. So terrorist activity is something where the motives are very clear. So now you remember that first one is that the laws which are made not just Indian state wants it, but the world is doing it. Second is that there are various complexities. Second complexity involves many people. The state is misusing, the NGOs are misusing, some intellectuals are misusing, and then the misguided people are being misused. And third is let us all understand the difference between a criminal activity and a terrorist activity. Every Hindu-Muslim riot does not become a terrorist activity. It is not that a Hindu has been killed in some riot or a Muslim has been killed in some riot. That does not make it a terrorist activity. That we need to understand. So what can be the possible motive for a terrorist, for a terrorist? That target is a state, not individual. Individual is just a wheel, just a tool. Unlike in crime, where individual is not a tool, individual is the target. A terrorist attacks sovereignty. In Jammu and Kashmir, last 2 days, 3 days, people are being targeted. Minority people are targeted. It is not a target on individual. It is a target on state. It is a challenge on the sovereignty. Then, what can be other motive? To press political or religious demand. You have political demand. You have a religious demand. Self-determination. Disintegration. These type of demands can be there. They do not believe in democratic process. This is one of the very, very significant point. That the terrorist group, be it Khalistani terrorist, be it Naga terrorist, be it Naxalite, be it jihadist, they do not believe in democratic process, and therefore all of them, when elections take place, they declare that no, nobody should take part in election. In Kashmir, in Jammu and Kashmir, when the panchayat election took place after many years, many decades, the terrorists declared that no, nobody should participate, otherwise we will kill, and they have killed many of them. Naxalites do the same thing. They do not believe in democratic process. They do not believe in judicial process also. They will always say that no, we don't have faith in judiciary. The flip side is that they take the benefit of judiciary, but they will always say they don't believe in judiciary. So if judiciary does something, if judiciary castigates the state for violence, they will appreciate, but the moment the judiciary says that no, this is completely wrong, this terrorist activity is completely wrong, this will not be permissible. Some people, some NGO, some alleged human rights activists are planning something, maybe to plan to kill the Prime Minister, maybe if they plan to commit some Naxal activity, if they are arrested, they will start telling that, oh no, my God, this is human rights violation. So they don't believe in judicial process. Recently a judgment has came, that is Himanshu Kumar judgment. Himanshu Kumar judgment, the petitioner had been slapped with 5 lakh rupees of fine because he has misused the judicial process. He has misguided the judiciary. It was a PIL was misused. Supreme Court has slapped a fine of 5 lakh rupees. Now we don't like it. Some of us say, no, judiciary should not do. Why judiciary should not do? Let us, even if maybe our democratic process is not ideal process, maybe our judicial process is not the best one, we will make it best, but then what is the alternative available to us? So let us believe in democratic process, judicial process, and let us make it more and better, but don't create a type of maybe disbelief, because if you don't believe in judicial process, democratic process, which process do you believe in then? Do we understand what type of anarchy will take place if we do not believe in judicial process and democratic process? A process like maybe China, which seems like a peaceful country, but what type of democratic values are there? No fundamental rights? Or we want to go this way of Afghanistan? So let us all rely on democratic process and judicial process. And anyone who does not believe in does not deserve any type of support. And other thing that I suggested, that there is a personal interpretation of justice. Personal interpretation. I will myself decide what religious text means. Even if the religious people will say, no, no, violence is not required, violence is not essential, the religious texts do not suggest violence, but they will say, no, no, the violence is essential. So these things suggest that these type of activities with these 4-5 element make and conduct a terror conduct. The aspect of religion has further been recognized in India by Law Commission of India in 156th report, where the Law Commission says that this small group of terrorists will always be there. छोटे ग्रुप हमेशा रहेंगे, वो इंग्लैंड में भी है, वो अमेरिका में भी है. They will always want secession, हमें अलग कर दो, हमें अलग कंट्री दे दो. छोटा ग्रुप ये मांग करता रहेगा हमेशा, हर कंट्री में कुछ न कुछ होते हैं. But then it says that but it says that what is more important for us, that this secessionist activity has reared its ugly head in countries which appear to have an integrated personality. बहुत ज़्यादा डाइवर्सिटी नहीं है, वहाँ भी टेररिस्ट एक्टिविटी होती है, सेसेशनिस्ट एक्टिविटी होती है. And therefore such political behavior, violence must be punishable. Not merely the violent act, but political behavior. Political behavior where you start shouting slogans, भारत तेरे टुकड़े होंगे इंशाअल्लाह इंशाअल्लाह, बंदूक के दम पर लेंगे आज़ादी, आज़ाद कश्मीर टाइप slogans. When you make, they should be made punishable. I will quote on the other side how People's Union for Civil Liberties and Union of India 2004 has suggested that terrorism is against democracy, state security, rule of law, sovereignty. That is correct. That is correct. But at the same time, PUCL judgment also recognizes that if you misuse the law, then you cannot deal with terrorism, because you will further propagate terrorism if you misuse the law. So we have to be very harmonious, and we have to be very delicate when we deal with this. I am just coming to then the part which can be said from philosophical part to legal part. What are the laws on terrorism? There are central enactments. Now Indian Penal Code 1860, Chapter 6, not Part 6, Chapter 6, Section 121 to 130, that is especially for anti-national activities. One of the provision is Section 124A, which was in use. Among the new laws, because IPC is a creation of 1860, among the new laws we find Preventive Detention Law, which is sanctioned by Article 22, National Security Act 1980. Then there are empowering laws also. Armed Forces Special Power Act 1957, applicable to Northeast now, and then Jammu and Kashmir. It was applicable in Jammu and Kashmir 1990. Armed Forces Special Power Act is not a penal legislation. It only empowers, only empowering legislation. Then there are exclusive laws like TADA, POTA, they were exclusive laws. Now UAPA, Unlawful Activities Prevention Act 1967. We have a special force which has to investigate only terrorism cases, though the law says they can investigate many other cases also. National Investigation Agency, it was passed in 2008. The act was passed in 2008, and then NIA does investigate terrorism cases. There are other laws also, including MACOCA, Maharashtra Control of Organized Crime Act. They also deal with terrorist activity. There is a provision for insurgency. Then there are state enactments also. For example, Chhattisgarh Special Public Security Act 2005 or Chhattisgarh Vishesh Jan Suraksha Adhiniyam 2005. Then we have act like maybe Jammu and Kashmir Safety Act So we have a number of laws which deal with national security and terrorism. I am just skipping this part, the laws which were there in India, which are there in India and IPC. Now, Terrorist and Disruptive Activity Act was passed in 1987, first in 85, then 1987. It was challenged before the Supreme Court. Supreme Court has declared it constitutional 2 times, both constitution bench judgment. One is Kartar Singh versus State of Punjab 1994, other is Sanjay Dutt versus Maharashtra 1995. Then POTA, Prevention of Terrorism Activity, it was declared constitutional in 2004 on POCL case. Both the acts were completely declared constitutional subject to one provision or two provisions. Then Armed Forces Special Power Act was also declared constitutional in 1997 in Naga People's Movement of Human Rights and Union of India. Then Sedition and IPC 1962, it was declared constitutional subject to reading into the clause that tendency of violence or disorder should be there. So these are the Supreme Court judgments. So not only Parliament has made law, but these laws were challenged, and the Supreme Court, either through Constitution Bench, mostly through Constitution Bench, indeed all 4 cases are Constitution Bench cases, they have declared unanimously that laws are constitutional. Now there are some criticism that the Supreme Court has declared such laws unconstitutional while they are not constitutional. Now such criticism has no ground. These laws are required, very much required. Why? Let me give you a small illustration from one of the book of Arun Shourie. Arun Shourie has written a book, and there is one chapter, and in one chapter it deals with terrorism. That book was published in 2001, so this data is 21-year-old, but you can understand the problem of terrorism. He says that in civilian, in terrorist attack in Punjab, 21,000 innocent persons are killed. In Jammu and Kashmir in 2001 itself, up to 2001 itself, 14,000 people has been killed. 21 years, you add 21 years, and you can easily multiply this figure by 3. So we have around more than 60,000 people, innocent people killed in terrorist activity. Tell me one democratic country where such a vast number of innocent persons are killed. And therefore Arun Shourie says, it is a war to break India, let us understand. It is not a war for justice. It is not a war for human right. It is not a war that has taken place because of some maybe revenge. कि भाई हमारे साथ बड़ा अन्याय हो गया इसलिए हम ले कर रहे हैं. No, it is a war to break India. Let us understand it. So this is the third perception. Arun Shourie also writes that in Punjab itself, and Punjab in terrorist attack in Punjab or maybe Kashmir and other places, Naxal attacks, we have lost around more than 2,000 police police officers. This is the data up to 2001. This has gone to maybe 9,000 police officers who have been killed. And then Arun Shourie asks that in which country 2,000 police officers are killed. One of the most threatened country was Britain by Irish Republican Army. No. And we lost 2 prime minister. Tell me one country where the prime ministers have been killed in terrorist attack. Chief ministers, we have lost chief ministers. We have lost many DIGs. Not to name SSPs and others. So let us understand the threat. And the Supreme Court had understood the threat. So anyone who says that this is a fight for human rights, this is a fight for justice, is indeed either he is ignorant or he has something else in mind. And that is why the Supreme Court has understood this thing and declared all the law as constitutional. So this is the fourth significant point that all the researchers should be very clear in their mind, that in the discourse for terrorism, there are discourse which are dominated by sometime by some ideological motive, the discourse which are dominated by some hidden agenda, the discourse which is not impartial, they are partial, the discourse which are sometimes motivated by maybe foreign forces. So let us understand and be very careful when we deal with the research under this. I have a lot to say. I will finally conclude telling that cyber terrorism is defined under section 66F of Information Technology Act. It was an amended provision incorporated in 2008 after 2008 attack on Shivaji Terminus in Mumbai or in Taj. And the whole purpose is that if the computer is contaminated, computer resources is accessed unauthorized without authority, with the purpose to disintegrate this country, to challenge the sovereignty and integrity of this country, that amounts to terrorism. But unfortunately, that definition is very vague. You will find that maybe defamation and contempt are also made part of that. I think it is a complete miss by the parliament. That only indicates that parliament is not serious in some cases when it comes to drafting. 66A has a great drafting error. So lastly, I would say that cyber terrorism has a very limited definition in India, but cyber terrorism is also committed when someone posts a violent video on YouTube or maybe Facebook, where they say that, okay, let us attack police, let us attack security forces, let us attack political people, or those who justify killing of Rajiv Gandhi, those who justify killing of Indira Gandhi, those who justify killing of maybe some chief ministers. These type of videos are emerging. Those who justify that the Pulwama attack was correct and they do it on video, that is also a type of cyber terrorism. I'd only remind you that UK has taken a very strong step, and you will be surprised to know that UK, which is supposed to be very much democratic country, we see it an ideal country, it has made a law under section 57 and 58 of Terrorism Act, where mere surfing of internet or mere downloading a material can make you can make you criminal if it is found that the content related to terrorism, and then an FIR, a first information report, can be registered. Now it is your duty to prove that you are doing it for innocent purpose. India do not have the provisions like that. So with that, I would like to conclude. I want maybe 5-10 minutes, if it is available, then we should do for questions. I will welcome questions, comments, agreement and disagreement. Thank you again, Team Asian Law College, for inviting me for this. All the best for other discourses. Thank you.
Yes, sir. We certainly have a lot of questions from our participants here. I would take some of them for reference. The first one is, don't you think that the act, whether related to terrorism in Kashmir or it is Naxalism in Chhattisgarh, the laws, instead of helping the local people, are actually becoming a threat for them? So what is your opinion on that?
Well, I would say that it is not the law which is to blame for it. To some extent, it is the enforcement of this law, not the law. So it is not the section but the action under law which may be creating some problem. But I do not agree with this view that it is creating more problem to the people and making them pushing them to terrorist activity. No, I won't say that. This is a type of thing which is projected mainly by some alleged human rights activities who always keep on saying that these laws are being abused, and they project some selective cases, which is not correct. So I would say that it is not that people are pushed because of these laws. Of course, if there is a misuse, then misuse certainly is not the way to tackle terrorism, because it will certainly make that person a hardcore person. So that should not be there. But the law cannot be blamed for that purpose. There is a whole design how to make people terrorist. There is a whole design how to radicalize people. There is a great training going on outside India for this purpose. And YouTube videos are now these days they are being used. And sometimes, unfortunately, Indian intellectuals are innocently or inadvertently or deliberately they are involving themselves in some those type of radicalized activity. So I won't say that it is the law which is the problem. Of course, there are maybe misuse of law. The misuse of law takes place, then there are recourses, and in that recourses, maybe this government is taking action. But the toughest law is required. We don't have still a tough law like UK. Thank you.
Yes, sir. So the next question is that there is a difference between being an anti-nationalist and a terrorist. But can we say that anti-nationalism is a progeny of a terrorist?
I do not know what is the difference between being anti-national and terrorist. The only difference is probably uh, mm, an anti-national movement can be maybe a non-violent movement, but terrorist movement is a solely violent movement. But the fine line between anti-national movement and terrorist movement is blurred. You do not know when the line is passed, and you are not aware of. So in the name that some movement is an anti-national movement, it is more an ideological creation. I won't say that. I would say that yes, it is one of the ideological branch of terrorist activities. Anti-national, being anti-national, is one of the branch of ideological creation of those terrorist activity. And sometimes people feel that I may remain non-violent, but the things go beyond their hand. So they start a movement maybe in the name of some justice, but there is another group which become violent, and the group which does not want to become violent has no control over that. So if you are think that by supporting some terrorist activity with the help of non-violent activity will do something, I don't think that is going to help.
Yes, sir. There is another question from our participant who is saying that considering sharing views on support of terrorist activity is also a type of cyber terrorism. But wouldn't it affect the fundamental right of freedom of speech and expression?
I think there is a complete misunderstanding about freedom of speech and expression. So this is something like this. I have a right to speak, means Mr. A, that you are a good person. I can say you are not a good person, but I have no right to abuse him. Huh? So this is this idea that supporting terrorism, supporting violence is not free speech under law. Supporting killing. So if I say that okay, Mr. A has killed his mother, so I would say that okay, mother was not giving in cell phone, लड़का क्या करता, मार दिया उसने अपनी माँ को. So can we say that it is free speech? It is not free speech. Free speech is not free to this level. It will lead to anarchy. This is something I see. Free speech is what? Free speech is like a highway. We all move our car on highway, but then on the highway there are red lights. On the highway there are zebra crossing. On the highway there are bumps made. Why? So that we have to lower our speed sometime. Suppose there is a signboard on the highway, school ahead. You have to lower your speed. When you lower your speed, does it violate your right? No. It is in pursuance of that right that if there are no red lights, if there are no zebra crossing, there will be anarchy, there will be accident. So if there is no limitation on these things, democracy cannot exist. We can see the position maybe in Sri Lanka, maybe in Myanmar, maybe in Pakistan, maybe in Afghanistan. So one group supports, another group makes bomb blast because they don't like it. So we let us learn from that, and that is one such reason that the free speech, absolute free speech type of thing in USA was rejected by Dr. Ambedkar in Constituent Assembly debate, when when an objection was raised that why under Article 13 that became 19(2) there are some limitation. Why cannot we make a provision like USA First Amendment where there is no express limitation? Dr. Ambedkar said that we are not following American model of free speech, we are not following. And then in 10 years after that, in 1960, in Babulal Parathe case, the Supreme Court also accepted it, that we are not following American model of absolute speech. So this is, I would say, this is the sixth confusion, that probably freedom of speech and expression is a type of absolute thing, and if we support that is a type of free speech. No, we don't have. We don't have that free speech, that you support terrorism, support killing in the name of justice. Even if maybe some good cause somebody is doing, we cannot support any type of violence. What to talk about terrorism?
Okay, so we have one final question, and that is, can we say that cyber terrorism is more severe threat to humanity than even a nuclear weapon warfare threat?
No, I won't go to that extent. That nuclear, I think I understand the concern, but I think it is sheer exaggeration to say that nuclear threat, cyber threat is more severe than the nuclear threat. See, what is a cyber threat? Cyber threat means any threat where you use the mode of computer, cell phone, remote. So these type of things you are using, internet, so that becomes a cyber terrorism. Nuclear threats are maybe different type of things. Indeed, nuclear threats are also conducted through cyber mode. Now, through cyber mode, they are being done. They can be done. See, when a nuclear threat takes place, things go beyond proportion. Things are not in our control, and then generations and generations have to pay for it. We know what happened in Japan and how they have paid generations after generations. So certainly cyber threat is a great threat. But if the question is the nuclear threat less dangerous than cyber threat? I would say that no, nuclear threat is still one of the most dangerous threat. Of course, nuclear threat coupled with cyber threat becomes one of the deadly threat. Thank you.